Thanks for stopping by and checking out my videos. And if you want to learn more about my book, Love Like Snow in Florida on a Hot Summer's Day, go down to the description. I have the links to both my website and Amazon and Kindle Unlimited, where you can read it for free. Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And the government has responded to the defense's response to the government's latest motions, okay? And they're basically responding to the July 23rd, 2021 motion in Limine, which they are trying to introduce, I believe it's 13 Jane Does and 2 John Does into the case as sort of like bad acts witnesses. And so I'm going to go ahead and read this. It was filed this evening, and this is a public redacted version, which means that some of this document has redacted information in which I cannot see. And so it says, Dear Judge Donnelly, the government respectfully submits this reply to the defendant's memorandum of law in opposition to the government's July 23, 2021 motion in limine to admit certain evidence and preclude other evidence and arguments at trial hereinafter def.op. For the reasons stated herein and in the government's original memorandum, the motion should be granted. 1. Evidence regarding behavior with anyone other than the defendant and others at his discretion should not be admitted. The defendant's response to the government's motion to preclude cross-examination or the introduction of evidence regarding victim's behavior with anyone other than the defendant or others at the discretion is nonsensical, makes no effort to comply with the requirements of Federal Rule Evidence 412, and contradicts the very reasons for the rule's existence. First, to be clear, the government does not seek to preclude or limit cross-examination or evidence regarding the alleged victim's interactions with the defendant or with others at the defendant's direction. See defense opposition at number 1. The government has failed to provide any justification for excluding evidence of the witness's conduct during the charged period, whether with the defendant or others. The government will elicit information from alleged victims regarding acts with the defendant and, where applicable, with others at the defendant's direction. The defendant may, of course, cross-examine the alleged victims as to such testimony. This does not mean, however, that he may stray into areas barred by Rule 412A. And then they quote a case, United States versus Thompson from 2016, which was in the Western District of New York. And it says, indeed, proving cases involving misconduct necessarily requires the government to introduce evidence of the behavior underlying crimes charged in the indictment. If the introduction of that evidence opened the door to the introduction of other behavior, evidence Rule 412A would serve no purpose. Second, while the defendant claims that his opposition is submitted per Rule 412C1, noticing the intent of the defense to elicit certain relevant evidence, ID at 2, he fails to comply with that rule. Rule 412 requires that if a party intends to offer evidence under Rule 412B, the party must A, file a motion that specifically describes the evidence and states the purpose for which it is to be offered. B. Do so at least 14 days before trial unless the court, for good cause, sets a different time. C. Serve the motion on all parties. D. Notify the victim, or when appropriate, the victim's guardian or representative. And then it goes on to say 412C1, emphasis added. The defendant provides no such specific description. See defendant's opposition at number 2, indicating without any valid explanation that A, at this time, the defense cannot catalog specific facts we intend to elicit. Instead, the defendant simply asserts that unspecified evidence of unspecified victims or alleged victims' predisposition and behavior with others unrelated to the defendant is somehow relevant because some of the charges allege some form of coercion and or force on the defendant's part. By its term, however, Rule 412 applies to criminal proceedings involving alleged misconduct, including those involving allegations of coercion or force. Federal Rules Evidence 412A, conclusory assertions that victims will purportedly open the door to such cross-examination and evidence their direct attorney, to such cross-examination and evidence in their direct testimony do not negate or alter the requirement that the defendant comply with Rule 412. Indeed, the unspecified general evidence the defendant apparently seeks to admit regarding victims' histories is precisely the sort of evidence that Rule 412 was designed to preclude. As the Second Circuit has made clear, the very purpose of Rule 412 is to preclude defendants from arguing that because the victim previously consented to have sex, her claims of coercion should not be believed. United States versus Rivera 799. And let me stop. And that was a case from the Second Circuit in 2015. So what it sounds like to me that they're trying to say is they want to be able to bring up evidence about behavior with him as well as him telling them to have sex with other people. But they don't want the defense to bring up the fact that during this time period when they claimed that they were being held captive and all this other stuff, that they were actually out there having sex with other people that had nothing to do with him, had nothing to do with R. Kelly. So they don't want them to bring in the fact that these women were free to come and go and see who they wanted to see, sleep with whoever they want to sleep with, do whatever they want to do. They want to try and narrow into this notion that they were being held against their will and they were forced, to sleep with him and to sleep with people, his friends or whoever he designated. And they want to keep out this other evidence about the behavior that they were conducting or engaged in, I should say. So nor does the exclusion of such unspecified evidence violate the victim's constitutional rights. Although a criminal defendant has a right to present his version of the facts to the jury so it may decide where the truth lies, it does not follow that a criminal defendant has a right to offer evidence that is irrelevant to the government's charges. Thompson, that was a ruling and explanation by a judge last named Thompson. Then it goes on citing Washington versus Texas, which was a 1967 case, and Taylor versus Illinois, which was a 1988 case. So evidence that a victim has engaged in acts with others unrelated to the defendant does not make it more or less probable that the defendant used force or coercion to engage in acts with any particular alleged victim. And then it goes on to cite someone, C.F. Taylor, and it says whether the victims engaging in acts of prostitution before or after their alleged encounters with the defendant would only prove other people may be guilty of similar offenses of recruiting, enticing, or causing these alleged victims to engage in a commercial act, citing United States versus Elbert, and that was from the 8th Circuit in 2009. So it says, nor has the defendant explained how a specific victim's or alleged victim's history is relevant to any alleged bias or credibility of that victim. While the Confrontation Clause guarantees a criminal defendant the right to cross-examine government witnesses at trial, United States versus Figueroa, which was from the 2nd Circuit in 2008, trial judges nonetheless retain wide latitude insofar as the Confrontation Clause is concerned to impose reasonable limits on such cross-examination based on concerns about, among other things, harassment, prejudice, confusion of the issues, the witness safety, or interrogation that is repetitive or only marginally relevant. And that was Delaware versus Van Arsdale from 1986. In this way, the examination is effective in whatever way and to whatever extent the defense might wish. Delaware versus Finsterer, and that was from 1985, and it says exclusion of admin. Lord have mercy. Exclusion of cross-examination regarding irrelevant acts does not violate a defendant's Sixth Amendment right to confront witnesses at trial, and that was from a justice by the name of Rivera. And then it goes on to say, finding preclusion of cross-examination as to irrelevant prior acts of commercial sex did not violate defendant's Confrontation Clause rights. United States versus Cephas, which was a case heard by the 7th Circuit in 2012, finding exclusion of cross-examination of alleged victim witness regarding prior acts of prostitution did not violate the Confrontation Clause because the evidence was irrelevant to the charged misconduct. United States versus Venezuela, which is a 9th Circuit case from 2012, and United States versus Overton, which is from the Western District of New York, December 13, 2017, finding evidence of acts of prostitution outside the indictment's time period were irrelevant to the charged conduct, and therefore Rule 412 exclusion did not violate Confrontation Clause, and that was by Justice Thompson. And it says, any alleged unchastity of a victim has no relevance whatsoever to the victim's credibility as a witness, and that was from Elbert. And it goes on to say, the defendant has made no attempt to specify what purported behavior or predisposition he intends to elicit or cross-examine witnesses on, or coherently explain how such evidence is relevant. Indeed, he does not even specify which witnesses he intends to cross-examine about such matters. In these circumstances, the government's motion should be granted. Now, they're saying he hasn't provided any specific information about what he's going to include, but keep in mind, you just gave them this information a week ago. Okay, and so they were responding within the time frame that they had to respond. So of course they haven't been able to go out and vet people and pull together their response because they only had a few days to respond. So let's go on to part 2, where it says the government does not seek to admit evidence of religious beliefs or experiences. As the court is aware, the government moved to preclude the defendant from cross-examining witness number 1. And by the way, witness number 1 is Demetrius Smith, line ass, okay? And so regarding his religious beliefs or experiences described in a book published by witness number 1 in 2011. In his opposition, the defendant has apparently misconstrued the government's motion as one that seeks admission of testimony from witness number 1 regarding his religious experiences, and the defendant sounding demonic. These people so messy, so messy. The government has no intention of eliciting any such testimony. As a result, the defendant should be precluded from cross-examining witness number 1 regarding these matters for the reasons set forth in the government's motion. And then number 3, the defendant should not be permitted to reference prior psychological histories. And that entire section has been redacted. And I can't remember if they were talking about Ariel in this. Because, several of these people, because remember, Ariel got into this whole situation when she claimed she was, so depressed about leaving her boyfriend or losing her boyfriend who dumped her. And then we have the Lizette Martinez chick. I think she suffered some psychological issues according to her, and she might have been one of the Jane Does, the one that met him in Miami at the mall or something like that. I don't have the paperwork in front of me, so don't quote me on that, but like I said, that whole section is redacted, so I don't know what they're talking about or who they're referencing. And then number 4, it says the defendant should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of certain victims. The government moved to preclude cross-examination and the introduction of evidence or argument that parents of any victims consented to the defendants having interactions with those victims while they were underage. The defendant appears to concede that any such alleged consent is not a defense to the charges. Instead, he argues that the conduct of the parents in allegedly seeking to profit from or extort the defendant is relevant because, presumably, the government intends to elicit testimony from the witnesses regarding a lack of access to their parents or the concern that the parents demonstrated for the witnesses or action that the parents made to connect to a child. The government does not intend to elicit from its witnesses any testimony regarding their parents, concerns for them, or actions the parents took to connect with their children. And I don't know why they're saying children, because there ain't no children involved in this case. So the government is just being really childish, petty, and messy at this point. So it says that the government will, however, elicit testimony regarding the defendant's efforts to monitor and otherwise limit Jane Doe number 5's communication with her parents. Such testimony regarding the defendant's actions does not render the conduct of any parent or of a alleged victim legally relevant to the charges at issue. As a result, the motion should be granted. So they're going to make sure to try and keep Angelo Clary and Alice Clary out of the witness stand. Okay, they don't want them testifying. They don't want them saying nothing because they know it will open the door for all this evidence that is out there about them and their shysty, shady doings when it came to Ariel being pushed on R. Kelly and this whole extortion plot and how they set this whole thing up, after he left, trying to secure her bag, which don't seem to be filling up no time soon. But basically, they will then not be able to enter any of this evidence that's out there, statements that the Clarys have made, the whole fight with Jocelyn, the whole interviews that took place on precedents, to contradict the interviews that were done on surviving R. Kelly. So they are going to do their best to keep the Clarys out of this case. But I hope that there is a way that the defense can bring them into this case, because the government knows that if the jurors hear anything about them Clarys, that is just going to kill their case with Ariel. So number 5, evidence regarding specific instances of the defendant's good conduct should be precluded. In opposing the government's motion to preclude the admission in evidence of prior instances of the defendant's good conduct, including awards and honors received in connection with his career as an entertainer, the defendant mischaracterizes the breadth of the government's motion. Contrary to the defendant's assertion, the government does not seek to preclude background testimony by the defendant should he choose to testify regarding his employment or personal circumstances, nor does the pertinent character trait pursuant to Federal Rules of Evidence 404A-2A. Instead, the government's motion relates to the manner in which such evidence may be admitted and seeks to preclude the admission of evidence regarding specific instances of the defendant's prior good conduct. Examples: specific prior good acts, such as testimony or evidence regarding specific awards or honors received in the course of the defendant's career, employment, or specific acts of charity. Okay, that sounds like a contradiction to me, but anyway. Rule 405 specifically sets forth the manner in which a person's character or character trait, where admissible, may be proved, and limits the matter of proof of testimony about the person's reputation or by testimony in the form of an opinion. Federal Rules of Evidence 405A, Rule 405B further makes clear that evidence of relevant specific instances of a person's conduct may only be used to prove a person's character or character trait when the character or character trait is an essential element of a charge. 405B, put simply, the defendant's character or character trait is not an essential element of any of the charged crimes. As a result, the only permissible manner in which he may prove a pertinent character trait is pursuant to Rule 405A, by reputation or opinion, testimony, not specific prior good acts. United States versus Doyle. Proof of defendant's specific acts admissible under Rule 405B because character was not an element of any of the charged crimes. These people are tripping. It says the defendant's reliance on United States versus Hahn from the Second Circuit from 2000 is therefore inopposite. While affirming the conviction in Hahn, the Second Circuit found harmless error in the district court's exclusion of testimony as to the defendant's reputation as a law-abiding citizen who does not exploit others. Similarly, the character evidence at issue in United States versus Puwana-Mina consisted of testimony about the defendant's reputation in his community as an honest and law-abiding person, not only specific prior good acts. Evidence of such specific prior good conduct should be precluded. So basically, they don't want nothing good to be said about R. Kelly. They probably don't want people to come in like Selena Johnson and K. Michelle and all the other artists that he helped who can say, yeah, he was really strict about recording sessions. Once we came in, we had to stay. We were locked in until the record was done, but it benefited my career. It helped my career. They don't want any of that stuff in there, to contradict some of these stories that these people telling about being held hostage and not being able to eat and all this other stuff. So number 6, evidence regarding Jane Doe. Number 8, subsequent employment is irrelevant. In his opposition, the defendant makes absolutely no showing that Jane Doe number 8's employment as a stripper years after the defendant had relations with her is all irrelevant, nor could he. Instead, he simply states without any explanation that her subsequent employment is admissible for proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake or lack of evidence, absent any showing of relevance, the government's motion should be granted. Child, she probably was a stripper when he was messing with her. I mean, I don't know. Anyway. Number 7, certain text messages by Jane Doe number 5 and relating to Jane Doe number 5 should be admitted. Child, please. The defendant summarily asserts that from a plain reading of the text messages the government seeks to admit, the messages would open the door to the very same evidence that the government is attempting to preclude, and asks that the court allow the defense latitude in cross-examination to explore the many topics included in the text messages, such as sexual behavior, psychological issues, and certain actions of witnesses' parents. In so saying, the government assumes that the defendant is referring to the text messages between Jane Doe number 5 and Jane Doe number 5's mother, and not other text messages the government seeks to admit. Even if so, the defendant has not explained and cannot explain how those text messages open any door to cross-examination. Rather, the text messages show only that Jane Doe number 5 recounted to her mother nearly in real time statements of the defendant, as Jane Doe number 5 will testify. The defendant suggests that prior consistent statements are admissible only to rebut a recent motive of fabrication and not simply to rehabilitate a witness. He is wrong. As an initial matter, he ignores that prior consistent statements are expressly permitted to rebut an express or implied charge that the declarant acted from a recent improper influence or motive in so testifying. Moreover, the defendant neglects to mention that Rule 801D1B was amended in 2014, expressly permitting prior consistent statements for the purpose of rehabilitation where a witness's credibility was attacked, adding that prior consistent statements are admissible to rehabilitate the declarant's credibility as a witness when attacked on another ground, and therefore the case law cited by the defendant all before the amendment is inappropriate. Number 8, the court should admit Jane Doe number 5's electronic note. The government seeks to admit an electronic note written by Jane Doe number 5, and you guys know Jane Doe number 5 is Ariel Clary, on August 30th, 2018, that contains the defendant's statements to her. Jane Doe number 5 will testify regarding the circumstances of those statements and the note. As indicated in the motion, the defendant's statements as contained in the note are highly probative of the defendant's commission of the forced labor offense as to Jane Doe number 5. The value of such highly probative evidence is not substantially outweighed by a danger of unfair prejudice. See Federal Rule Evidence 403. Indeed, it is direct evidence of the crime. See United States versus Curley from the Second Circuit in 2011, noting that for evidence to be unfairly prejudicial under Rule 403, it must tend to have some adverse effect upon a defendant beyond tending to prove the fact or issue that justified its admission into evidence. So basically, what they're saying is, I could send somebody a text message, right, that says, yes, I want to go to the park. Now, I might have wanted to go to the park because there was something happening at the park, or I may have wanted to go to the park to walk. I may have been telling the person, yes, I'm going to the park, because they wanted to know what was I about to do, because they wanted to do something else. But according to this, they're saying that Ariel can read this text message from R. Kelly and basically just make up her own narrative about his state of mind, what he meant when he sent the text message, what he was expecting from sending that text message, which to me is hearsay and is leading, the jury into a narrative that may not be true. And then maybe they do this stuff because they know in most cases the defendant isn't going to get up on the witness stand and testify. So they can basically put all these fake or false statements out there into the universe. And without him getting on the stand and rebutting what she's saying, then it kind of sticks in the juror's mind as the truth, unless his attorneys can basically get up there and put his words into their questioning and cross-examination of her. So number 9, the admission of certain newspaper articles is warranted under Rule 803.16. As clearly set forth in its motion, the government seeks to admit newspaper articles from 1994 for the following purposes: to show that 1, the defendant performed in Macon, Georgia on August 30th, 1994, in Albany, Georgia on August 31st, 1994, and in Miami, Florida on September 2nd, 1994. And 2, witness number 1 was in fact the defendant's tour manager on August 31st, 1994. There is nothing circular or confusing about the intended purpose of such articles. Such evidence is relevant for the reasons stated in the government's motion and is admissible pursuant to Federal Rules Evidence 803.16 and 902.6. And then number 10, sealing. The government requests that the court permit the government to file both a sealed and redacted public version of this motion. The redacted version will redact certain content from the publicly filed version of this motion that details medical and other private matters of certain witnesses. See United States versus Armadillo. And I don't know why, if they're talking about Lizette in this, either Azriel or Lizette, in that portion that they redacted, both of them have made public knowledge their mental health issues and seeking psychological counsel. So I don't know why it would be important to have redacted that. And then number 11 is the conclusion. For the reasons set forth and in the government's July 23rd, 2021 memorandum, the government's motion in limine should be granted. And then, the crew, Elizabeth, Nadia, Maria, the assistant U.S. State's attorneys. So basically, this is their response to the defense's response. And then I'm sure the defense can respond also. But time is running out, y'all. Like all this back and forth. Judge Dunley needs to rule whatever she's going to rule. And then we can move forward from there, because at this point it's just eating up the clock as it goes into, when is the trial supposed to start? August 18th. So, technically it's down to 15 days at this point. So I am going to research. I already researched that 404 and I talked about it, 403 and 404. I had previously researched and talked about in a previous video, but I'm going to go back and look at some of these other federal rules that they have listed in here. And then I'll come back with another video this week, kind of explaining what these motions are, or these federal rules are, in terms of entering these bad act witnesses, their testimony, what's allowed, what's not allowed, and if A happens, then B can happen, and that type of thing. So that's it for me. I'm going to call it a night at this point. Okay, go ahead. Leave your comments below, rate the video, subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.